Legislative power is the power to create, amend, and repeal laws. The power of inquiry is inherent in the legislative process and implied in the express power of legislation, such that the former does not have to be expressly granted by the Constitution. Hence, the 1935 Constitution did not explicitly address the legislature's power of inquiry in its provisions. That the 1987 Constitution provided a provision for inquiries was in fact to delimit the conduct of inquiries.
In the 1987 Constitution, an express provision was stipulated, codifying Congress' power of inquiry where it must be exercised in aid of legislation and in accordance with its internal rules where the rights of persons appearing in or affected by such inquiries shall be respected.
Legislative inquiries enable the legislative body to gather information and thus legislate wisely and effectively, and to determine whether there is a need to improve existing laws or enact new or remedial legislation.
Numerous laws have been legislated through conducting inquiries, such as the Anti-Hazing Act of 2018, where it introduced amendments to Republic Act 11053 law after conducting inquiries and probing the death of Atilio Castillo, among others. This led from a regulation on hazing to its absolute prohibition.
Throughout 2024, however, congressional hearings, including pros pogos,
Masasabi ko po, isa po akong victim.
the OVP budget and confidential funds,
Do not vote for Sara on 2020.
human trafficking allegations against Kibuloy,
Tinatanggi ko po, wala pong mga katotohanan yung kanilang mga sinasabi.
and the Duterte drug war, among others, have raised great intrigue from the Filipino society.
What we are witnessing now is no ordinary legislative inquiry. This exercise is a well-funded and coordinated political attack.
Various publications have sparked debate about the true purpose of legislative inquiries in aid of legislation, raising concerns about how many hearings actually lead to committee reports that contain recommendations for legislation. Some have criticized these inquiries as politically motivated, prioritizing spectacle and public intrigue over substantive legislation. Recent instances where Congress used its contempt powers have been subject to scrutiny, where nearly every week, news outlets report on contempt charges against resource persons, generating significant media attention.
Critics argued that these hearings, driven by individuals seeking publicity ahead of elections, stray from their constitutional purpose and instead serve as platform for political maneuvering rather than genuine legislative work.
Legal experts have described Alice Guo's case as a complicated legal situation, as she faces multiple cases in various Philippine courts. Congress required her to testify about her identity, which could lead to self-incrimination. As a result, she refused to answer several questions, leading to a contempt citation for allegedly being dishonest and evasive.
180,000 and then you didn't bail out? Hindi ka nag-bail? A deliberate move to you, from you, with your lawyer, na hindi kayo nag-bail kasi mas gusto mong nakadetain doon sa PNP custodial facility. Kaya hindi kayo nag-bail. You're lying. Because the real reason why you didn't bail out because you want to be detained doon sa PNP custodial center. Again, you're lying. You're fooling the Filipino people.
Her case is not unique. The Dargani twins, former police Colonel Lorena Garma, members of the Aegis Juris Fraternity, and attorney Zuleika Lopez have all invoked their rights against self-incrimination during Senate or House inquiries to avoid unintended legal consequences, only to be cited in contempt for failing to answer questions or the lack thereof fit to the legislator's contentment.
Are you the head of that fraternity? Your Honor, being a member officer is part of its element po. So I'm invoking my right.
Again, may I remind you, don't force us to cite you in contempt, ha?
You are
Do
a
not force us because mong i-irritate yung mga members dito. A very simple question of your position and you're invoking your right against self-incrimination? Come on.
On one side, Congress is demanding the truth, while on the other, witnesses refuse to speak to avoid legal consequences. With the threat of being cited for contempt and facing indefinite detention, witnesses are forced to either speak against their will or risk imprisonment, sometimes in facilities alongside other detainees or convicts outside of Congress buildings.
If we look at it through the lens of new institutionalism, which is about how institutional structures, rules, norms, and cultures shape the choices and actions of individuals, like Bruning and Ishiyama mentioned in 2023, the legal boundaries of legislative contempt are clearly outlined in the established internal rules of procedure of both houses of Congress.
Both houses have balanced its sui generis contempt power by the resource person's right against self-incrimination. The respective rules from both houses are similar in that a resource person may be held in contempt when he or she refused to obey summons, refused to take oath, refused to answer relevant questions properly, refused to produce possessed documents or objects, shows disrespect, and interferes with the proceedings, and the controversial rule in the Senate involving a resource person testifying falsely or evasively. These rules are in place to provide safeguards.
Here's where the problem comes in. Sometimes congresspersons interpret those rules on their own terms. A good example is the case of Uy Ong versus the Senate Blue Ribbon Committee. The Supreme Court actually ruled that the committee didn't have enough evidence to say Mr. Uy Ong was testifying evasively and falsely, which was the reason they cited him for contempt and detained him. They pointed out that considering the lack of definition of giving false or evasive testimony, the witness must, at the very least, be given a chance to explain why his or her testimony is not false or evasive in the first place. In the case, the committee's grave abuse of discretion lay in its immediate act of citing petitioners Ong and Yang in contempt and ordering their arrests without giving them the opportunity to be heard.
Although there are established rules of procedure, the misinterpretation of these rules can be an avenue for error. Institutional constraints, in this case, have failed to contain a misinterpretation of their codified rules. Therefore, there must be more stringent measures that would contain such an issue of semantics.
In the halls of Congress, the power to hold individuals in contempt is not just a tool. It is essential for the institution's ability to conduct its inquiries. As the Supreme Court put it, the power to punish for contempt is the means by which Congress can enforce or compel obedience to its directives in the course of its investigation, for without this power, Congress would struggle to gather the information needed to carry out its duties and create meaningful laws. While Congress' contempt power ensures compliance, it also intersects with the individual's right to self-preservation, particularly when the right against self-incrimination comes into play.
You are not incriminating yourself. So, are you guwo-huaping?
Madam Chair, may mga kaso na po na final po sa akin po sa court, kaya hindi ko po siya masagot po sa inyo ngayon.
When resource persons or witnesses invoke their right against self-incrimination, it's really about protecting themselves. And if you look at it from a rational choice theory perspective, it makes sense. People are essentially acting in their own self-interest, trying to avoid any potential harm.
Now, for those subpoenaed to appear before Congress, especially high-profile or legally troubled individuals, every word they say is a risk. If they answer in an incriminating question, they could open themselves up to legal consequences or even get dragged deeper into controversies. Just showing up for the hearing puts them in a vulnerable position.
On the rules of procedures of Congress, witness protection against self-incrimination is afforded to resource persons. They may not be compelled to answer a question provided there is reasonable ground to fear self-incrimination that would expose them to legal liability. The problem lies when there are different perceptions of whether a question asked in a legislative inquiry is incriminatory in nature or not. There are instances in Congress when the witness invokes his or her right against self-incrimination. However, the legislators perceive otherwise, that there was no incriminatory question in the first place, thus inadvertently compelling the witness to substantiate an indication of guilt that was initially avoided.
The chairperson already stated that it will not in any way incriminate her, Madam Chair. Just to put that on record.
Salamat, Sen. Joel. Exactly.
Naturally, the witness doesn't want to put themselves at risk of legal trouble, which could harm their case. If they were thinking rationally, they'd probably try to avoid the situation altogether, or at least not answer any questions. But that tactic is assailed as, in Sabio v. Gordon, the right may only be invoked on a question-by-question basis. The witness cannot refuse to testify entirely, but may refuse to answer specific questions that tend to incriminate them.
Despite the Constitution's explicit provision that the rights of persons appearing in or affected by such inquiries shall be respected, the absence of specific protective mechanisms such as clear definitions in the internal rules, and the ambiguity surrounding what truly constitutes an incriminatory question leaves individuals exposed to coercion and potential imprisonment. As long as the political agendas of legislators shape the conduct of these inquiries, the risk of abuse and the erosion of democratic governance and public trust in legislative institutions remains ever present.
Miss Alice.
The preservation of the sanctity of the right against self-incrimination during legislative hearings must be reinforced, and the law, or at least the internal rules of Congress, should clearly state that once a witness invokes this constitutional right, it must not be taken lightly. To protect this right, the internal rules of both houses of Congress should adopt a provision that clearly defines what constitutes testifying evasively or falsely to lessen any abuse of discretion by legislators. This provision should also include the due process clause, in line with the Supreme Court's ruling, to ensure that witnesses cited for contempt on grounds of giving false or evasive testimony are given the opportunity to explain why their testimony is not false or evasive. A clear boundary needs to be established in congressional inquiries to determine which questions are incriminatory and can be avoided by invited resource persons. These recommendations may be considered by the upcoming 20th Congress when they promulgate their rules, adding provisions to the rules governing the conduct of inquiries in aid of legislation. Ultimately, the integrity of these inquiries must be protected to preserve public trust in justice.